Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we haven't touched on the R. Kelly case in the past couple of days, mainly because my throat had been killing me. You guys know when I read the last of the transcripts that I had, that I was losing my voice because it was raining here a lot, and me and the wet air don't mix, and so I always lose my voice when I'm out in moist air. So for the past day and a half, it has not rained, and I'm getting my voice back, and so that is a good thing. So what I want to do today is, you know that the prosecution rested their case on Monday morning, and then the defense took over immediately, and the defense only has about 6 witnesses that they are going to call. Court was cut short yesterday because one of the witnesses was unable to get to court, and so Judge Donnelly broke for the day so that they could figure out their witness situation. They did have 2 witnesses, I believe. One was a former rapper who Kelly had been working with prior to his arrest. I think the guy said that he had known him for quite some time. Let me scroll back up here. So the first person to testify, his name was Dana Ramanan, and he was an aspiring singer who had worked with Mr. Kelly since 2005, and he described Kelly as a mentor and a good friend, and said that he never witnessed him verbally abuse anyone, especially women, nor stop anyone from eating or using the bathroom. And he was quoted as saying, whenever we go to a restaurant, they'd sit down first, referring to women, and that they would order first and they got to eat first. And he was referring, to all of the star's girlfriends. And he was just basically talking about the mannerisms of R. Kelly and how friendly and chivalry, he was. Like, he was someone that respected women and treated them respectfully, at least as in public. And so on cross-examination, the Cruz Melendez lady cross-examined him, and she tried to bring out the fact that him and Kelly weren't that close of friends, that he was somebody, I guess, that he only knew because he wanted him to help him with this music. And I think it also came out that there was a single that he was able to finally finish, but the reason it didn't come out was because it was around the time that all the interviews were taking place, all the negative press. Surviving R. Kelly was about to be released, and so they thought it would be a good idea not to release the music. And we know that I know that to be something true, because if you follow Julius Darrington, who is the A&R person, or was the A&R person for Kelly before his arrest, he had often talked on his IG page about the fact that there was these artists who were about to have their music released, and then all of that was put on hold, put on pause, because they didn't want to release the music, and all of this was going on, and they didn't want that to impact these artists. And then the guy, the Dana guy, he actually had a copy of the single, and he asked the judge if he would be able to play it. And of course, Donnelly was like, absolutely not, you're not going to play that. And that was pretty much the end of his testimony. And then the second person to testify was a guy named Larry Hood, who was a former police officer and a childhood friend of Kelly's. And he basically testified that he didn't witness, any bad acts, him abusing people, etc., etc. It did get revealed that he had been convicted of forgery, basically passing off counterfeit $100 bills. So I don't know if he knew they were counterfeit or if he found out later they were counterfeit, but he does have a record for that. He stated that the prosecution on cross-examination, they brought up the whole Aaliyah situation, and he did admit that he recalls seeing what he referred to as little Aaliyah and a group of her, quote, hype girls when she first met Kelly in the early 1990s. And then he was asked how old was Aaliyah, like was she 12 or 13? And he replied that she was a young lady, yes, that he believed she was around 12 or 13. And they felt that this was crucial. The prosecution felt that was crucial because if you guys remember, Javante Cunningham testified. She was one of the last witnesses to testify, and she told that tale about how they were at the apartment, at Kelly's apartment. Her, Tiffany Hawkins, and some Aaliyah and some other young girls or whatever were at the apartment in a bedroom doing some stuff they had no business doing, and she named the Larry Hood guy as one of the people that was in that room. And so we know that this is probably one of the things that the prosecution made up because they knew that Larry Hood was going to be a witness. And so they did that probably to discredit him. But he replied when they were asking him about that, he replied that as a police officer, like he would have been a police officer during that time, and he would have been obligated to step in and act upon whatever was going on in that room, that he wouldn't have just sat there and watched these young girls going into this bedroom, right? And then he said that he didn't know about the illegal marriage that was allegedly took place between Aaliyah, that he learned about that later on in life. He didn't say how much later in life he learned about it, but he said he was not aware of it when it actually took place. He recalled hearing something about it, I think in the media, but he didn't really learn about it until later on. And so then they ended court because the next witness was not available. And then they picked up again today. And I believe there were 2 witnesses. Was there 2 witnesses today? I know one of the witnesses was an accountant. And I want to say there was another witness. But basically the accountant talked about... he came in because Kelly was $13 million in debt, and then or $12 million in debt, and he was hired to work out the numbers and figure out what was going on, and he was able to eliminate a lot of that debt, the vast majority of that debt. And then he also testified, basically telling who was on the payroll. And a lot of the people, they were employees, like Julius Darrington, who was the A&R guy, who I mentioned before. He was on payroll. Then other people that worked for him, his assistants and all of that. And so I guess he went on, about whatever was going on with the payroll and him reducing the debt. And so those were the only people that have testified. Then there was some back and forth about a expert witness that was supposed to testify. And so there was a letter that was written. Let's see, is this the one? It was written by the scholar, Calvin Scholar, who's the other attorney. And you guys, have you noticed that we have not heard from Thomas Farinella or Nicole Becker like in weeks? Like they are just sitting there quietly, I guess, like they have been banned. Looks like Kanik has just taken over completely after a few gaffes that Nicole made earlier on in the trial, but it doesn't seem that we have heard from them in quite some time. So in this letter that Scholar wrote to the prosecution, it says, "Dear counsel, pursuant to Rule 16A1G of the Federal Rules of Criminal Procedure, the defense hereby notifies you that it intends to call at trial in the above referenced matter Dr. Kimberly Resnick to testify about the matters described below, and Dr. Resnick's curriculum vitae was previously provided and is attached. The defense reserves the right to call substitute expert witnesses." And then Dr. Kimberly Resnick is an associate director in the Forensic Psychiatry Fellowship Department at Columbia and Cornell, chief of forensic psychiatry at the Mid-Hudson Forensic Psychiatric Center, an assistant clinical professor of psychiatry at Columbia University, and an adjunct assistant professor of clinical psychiatry at Weill Cornell Medical College. Dr. Resnick maintains an active faculty practice in psychiatry and psychotherapy and is board certified by the American Board of Psychiatry and Neurology in general and forensic psychiatry. In addition to her clinical and hospital responsibilities, Dr. Resnick is involved in medical student education and supervises psychiatric residents and forensic fellows in training. At trial, Dr. Resnick will testify mainly to rebut the testimony of the government's witness, Don Hughes, and will testify as to the process that a forensic expert should conduct when offering an opinion in legal matters, specifically at trial, or especially at trial. Dr. Resnick will testify that it is atypical to provide an opinion on forensic psychological issues without examining the witnesses. In addition, Dr. Resnick will testify that the areas of child abduction, priests, and Boy Scouts would have no relevance depending on the specific issues of the case. Dr. Resnick should also testify that spanking, BDSM, role play, and fetishes should not be automatically attributed to atypical relationships. Very truly yours, Charles Scholar. And then he provided her resume to the courts. And so Donnelly basically doesn't want him to, like, the witness will be allowed, but Donnelly doesn't want her trying to discredit the Don Hughes lady, because what happened is the Don Hughes lady got on the witness stand and was basically saying all of this stuff about the abuse that Kelly allegedly subjected these Jane Does to, and the effect and how they would respond. But then on cross-examination, Canick got up and basically asked her 3 questions, and from those 3 questions we learned that the lady had not talked to any of the Jane Does, and that she hadn't even read any of the testimony or the transcripts from their testimony in the case, never met them or anything, but here she was giving this expert opinion. And then speaking of this lady, there's also supposed to be an expert. I'm not sure if the guy is still coming or not, but I know they submitted documentation earlier on where there was supposed to be a herpes expert who was basically going to come in and say that there's no way to tell who gave who herpes, and just explain how, I guess basically the Dr. Chris McGrath kind of dispute his testimony about how often he was prescribing this Valtrex, which I think we later found out that it wasn't just Kelly who was taking the Valtrex, that some of the girlfriends was also taking the Valtrex. So that might have explained why there were so many prescriptions being filled. So I'm not sure if that person is still going to come. And then there's supposed to be an investigator. I'm not sure if it's the Blight guy that was, he did a a YouTube video addressing Dana J or something. And I believe he's going to testify if it's the same guy, but there's definitely an investigator. And then I thought Geronda Pace's friend from the trial, Kiona, or whatever her name is, that she was also supposed to testify, and maybe she's the one that was having trouble getting there. But I will say that I am very, very surprised that Julius Darrington is not a witness. That has been a real surprise to me. I was kind of hoping Jocelyn would testify, but then I don't know if she would have held up under the prosecution, who basically would have been trying to convince the jury that Jocelyn was suffering from Stockholm syndrome. Like, I think that would have been the route that the prosecutors would have taken. So that might be why Jocelyn isn't testifying. And then I thought Sharon Winbush had stated that she was going to testify, but that doesn't seem to be the case. And then where is Will Eady? Where is Ruby Chris? Where are all these friends that claim they had his back? They are the bros. Where's Keith? Where is the guy, the real tall guy? Or maybe he's the police officer, but you know, the tall security guy that has been with him for like forever. Is that the police officer? Is that the Larry Floyd guy? But like, where is he at, to testify? So it doesn't appear that any of those people are coming. So it will be interesting to see how they wrap that up. The judge seems to believe that the case is going to the jury by the end of the week. And so the defense was saying in some of their documentation that they had given 6 names, but they said there could be more people that they present to the courts. But those are the people that I thought for sure would have been there to testify. But then again, the judge did say she didn't want a lot of character witnesses. But I would think that like Julius wouldn't have been a character witness. He would have been a professional witness because they spent a lot of time together. He could have testified to what was going on in the studio and stuff like that. Jocelyn, I'm sure Kelly probably told her, no, I don't want her testifying. I think he would protect Jocelyn and not want her to get up there, especially, after they played the video and the audio tapes with Dominique and Lisa Van Allen. The prosecution has just been very low down, dirty, and under the table. And I haven't really talked about the past few days of testimony because I am going to wait until those transcripts come available. But hell, by then, the case could be over with and a verdict could be written. Already read by then. But just real interesting how this thing kind of just wore thin at the end. Even as the prosecution was winding up, you could tell that a lot of interest was being lost. The media wasn't reporting about it anymore. Like, they were reporting, but not with the same energy that they were reporting in the beginning. People who are at the courthouse that was reporting for different blog sites and newspapers, like, they weren't live tweeting, with the same enthusiasm that they had been doing in the beginning. So it would be very interesting to see what the end is going to be. Now, what I really came on here to do was to read the opening statement from the prosecution and to give you guys a breakdown of the key witnesses that have testified throughout this trial, since the prosecution has rested, and now the defense appears to be resting soon. So what I'll do is I'll do the prosecution and their witnesses, and then I'll come back and do another video probably tomorrow of the defense's opening statement and what they promised, and then give you guys a better breakdown on what happened with the witnesses that they called. And then I'm going to do another video because there was some documents that were filed about the jury instructions, and so that'll be important and something that you guys may be interested in. So now let's go ahead and jump on these opening statements and what the prosecution said that they were going to prove in this case. And once again, you know, the United States was represented in the Eastern District of New York, and the attorneys in this case was Elizabeth Geddes, Nadia Shahada, and Maria E. Cruz Melendez. And I believe it was Melendez who actually did the opening statements. Before the opening statements began, there was some conversations with Donnelly, and they talked about the different people who were in the courtroom at that time. And then Nicole Becker brought up something. And then, of course, Donnelly was talking about, even from the beginning, she was talking about these doggone microphones and telling them, you know, they were talking about outstanding motions and written motions and all of that good stuff. And it says they were talking about evidence. Wait, I'll just read this to you guys before they even got to the opening statements. So Donnelly said, "Good morning, Nicole. Good morning, Your Honor. Nicole Blank Becker, Calvin Scholar, Devereaux Canick, my client, Mr. Kelly, and Mr. Tom Farinella on behalf of the defense, and we are ready to proceed." Then Donnelly, "Okay, good morning, everybody. Just a couple of preliminaries before we begin. First, I want to remind everybody to microphones on both sides so that people in the overflow room can hear. With respect to the outstanding motions, these will be followed by written motions. The motion to dismiss is denied in all aspects. I have an exception to that ruling. As I said, there will be a written decision filed shortly." And Donnelly has yet to file that. And if she did file it, she filed it under seal because it's not out on Pacer yet. With respect to the outstanding motions in limine, I adhere to my decisions that I made at our final pretrial conference on August 3rd, but let me review the outstanding motions in limine and let me know if I've forgotten one. The first has to do with the alleged abuse of Jane Doe number 7, a minor, in 1991. That is granted only insofar as there is evidence that Jane Doe number 7 witnessed the alleged abuse of Jane Doe number 1, and so number 7 is Javante and number 1 we know is Aaliyah. She says that's admissible for the same reasons that I ruled that evidence about Jane Doe 1 was admissible. The remaining evidence is not admissible about Jane Doe number 7. The conduct is alleged to have taken place before the enterprise began, so I am excluding that. The second category of evidence is the alleged abuse of Jane Doe number 9, a minor, in 1995. Evidence that Jane Doe number 9 informed the defendant she contracted herpes from him is admissible. It goes to acknowledge for the charged acts of racketeering, acts 12 and 14, as well as in counts 6 through 9. The evidence is not unduly prejudicial and no more sensational than the conduct that's charged. The other allegations regarding Jane Doe number 9 are not admissible. And who did we say was Jane Doe number 9? Was that Lizette Martinez, I think, who never was even called to testify. And she said that they never even reached out to her to testify. But there was a sidebar in one of the court dates where they were talking about whether or not she could appear via video camera. I think the judge was like, why can't she appear on video? But the prosecution wanted her there. But according to an article I read, they never reached out to Lizette to even appear. So the third outstanding motion in limine was the alleged exposure of Jane Doe number 11 and 12 to a sexually transmitted disease in 2001. The evidence that Jane Doe number 11 informed the defendant that she contracted herpes from him is admissible for the same reasons that I just described from Jane Doe number 9. The evidence of the settlement agreements with victims is also admissible. It is direct evidence of the enterprise and the means and methods, specifically the steps that the defendant and other members of the enterprise took to conceal what was going on and to perpetrate the enterprise, which makes zero sense. So the next category, especially when you heard Jane Doe 11's testimony, what Donnelly just wrote there made no sense, or said there made no sense. So the next category, and then we know that the Jane Doe number 12 is deceased, so I don't even know why anything about her would be included. So the next category is the alleged unlawful imprisonment of Jane Doe number 14 in 2008. That is admissible. It is not unduly prejudicial. It is direct evidence of the enterprise and its means and methods. And I can't remember who was Jane Doe number 14, and I'm thinking they probably weren't even called. So the only other issue was this question of whether the parties were going to stipulate to the dates of concerts that took place. What was it in Georgia? And then Miss Getty says, yes, Your Honor, in Georgia. And then Donnelly, did you stipulate to that? And then Getty's, it's my understanding that defense counsel is going to stipulate to all of the dates, with the exception of the one newspaper article the government sought to admit that showed that Demetrius Smith was present at one of the concerts in a way that would directly corroborate Mr. Smith's anticipated testimony regarding Racketeering Act number 1. And then Donnelly, are you going to deny that he was? Is the defense going to deny? I don't know who this person was, but are you going to deny that he was there? Just use the microphone, okay? Then Nicole replied, thank you, Judge. Judge, it's not a question of whether we're going to deny that he's there. It's a question he's going to take the stand. So we think the best evidence will come when he takes the stand. They can just ask him that question. And then Donnelly, well, that's my question. Are you going to challenge his testimony that he was at the concert? It seems of vanishingly small importance to me, I have to say. There is an article that he was in at this concert. If you are going to dispute that he was actually there, I will let the prosecutors introduce evidence from the newspaper. It's up to you. Then Farinella jumped in and said, Your Honor, one moment. Then Nicole replied, thank you, Judge. And she was getting on my nerves with that thank you, Judge stuff. Judge, at this point, we are not going to stipulate to that. We are going to challenge that. Donnelly, okay. So if he testifies that he was there and he's cross-examined on it, the government can introduce the newspaper article showing that he was there. I think that's it. So let me just say that in the opening instructions to the jury, I am going to just describe in general terms what the case is about, just as I did when we selected the jury. I used that same language that I used then. Oh, I know what the other thing was. The question about whether Jane Doe number 5 could testify. Did I already rule on that she could testify using a pseudonym? Geddes, yes, Your Honor. I believe you ruled and approved her testimony. Donnelly, that's what I thought. All right, I think it is probably appropriate to include a general instruction that some witnesses will be testifying by their first names and explain that the reason is that this is not uncommon in cases like this where they might be testifying to things that are potentially embarrassing. Okay, and just remind me, is one of the witnesses testifying? I don't know what to call it, using first names and then Getty's nicknames, then Donnelly or nicknames. Okay. All right. Anything else that anybody wants to raise? Nicole? No, Judge. Donnelly? All right. I think we are ready for the jury. So the jury enters. Everybody be seated. Donnelly, good morning, ladies and gentlemen of the jury. The jury replied, good morning, Your Honor. Donnelly, we are about to begin the trial in the criminal case for which you were all selected as jurors. I am going to give you some preliminary instructions and also give you an overview of what will happen during the course of the trial. Your job as jurors is to administer justice in this case according to the law and according to the evidence. You must carry out your duties as jurors with complete fairness and impartiality and without bias, prejudice, or sympathy for either side, either for or against the government or for or against the defendant. I am going to give you a summary of charges. Again, this is just a summary of charges. It is not evidence. The defendant, Robert Sylvester Kelly, is charged with racketeering in violation of Title 18 United States Code Sections 1962C and 1963. For his alleged role as a leader of an enterprise, he is alleged to have engaged in racketeering acts that include bribery, sexual exploitation of a child, kidnapping, transportation of minors and other people for the purpose of engaging in illegal sexual activity, illegal coercion, and enticement of individuals, and forced labor. Mr. Kelly is also charged with violations of the Mann Act, including the transportation of individuals, including a minor, for the purpose of engaging in illegal sexual activity and illegal coercion and enticement of individuals, including a minor, in violation of Title 18 United States Code Sections 2421A, 2422A and B, and 2423A. Mr. Kelly has pleaded not guilty to all of the charges. It is the government's burden to prove Mr. Kelly's guilt beyond a reasonable doubt with respect to each charge. As I told you when you were selected as jurors, the indictment is the document that brings the case to court, but it is just an accusation. It is not evidence of anything. The government has the burden of proving, as I just said, each of the essential elements of each crime that's charged beyond a reasonable doubt. The purpose of the trial is to determine whether the government has met this burden. A defendant in a criminal case does not have to prove innocence. On the contrary, the defendant is presumed to be innocent of the charges in the indictment. One of your jobs as jurors is going to be to determine what the facts are based on the evidence. You as jurors are the sole judges of the facts. You will then have to apply to those facts the law as I will give it to you, and you must follow that law regardless of whether you believe in it or not. Because I am the judge of the law, I will make legal rulings, including on objections, or I may direct the lawyers to move along so we can keep the case moving. Do not assume that because I make a ruling that I have some opinion about the case or about what your verdict should be. I don't have any such opinion. Sometimes during the course of an examination, I will ask a question of a witness. If I do that, it's either because I don't understand a particular question or because I think somebody needs to be clarified for you. And Lord knows we know she did a whole bunch of clarifying during this trial. So again, don't assume that just because I ask a question that there is some importance to it or that I have an opinion about the case. As judges of the facts, you will listen to the evidence. The evidence consists of the testimony of witnesses on direct examination and cross-examination, documents and other exhibits that come into evidence, and any facts on which the lawyers agree. These are called stipulations. There are other things that are not evidence, and you may not consider them. What any lawyer says during the course of a trial, whether it's an opening statement or if it's in an objection or if it's in a summation, is not evidence. With respect to objections, lawyers do have an obligation to make objections if they think there is a reason to object. Do not hold it against lawyers if they do object. That's part of their job. If I sustain an objection, it means that I have determined that the question is not a valid one and you should ignore the question. If I overrule it, that means I have determined that the question is proper. Sometimes a witness will answer a question even though I have sustained an objection. If that happens, I would just instruct you to disregard the answer. Another thing that is not evidence is anything that you have heard outside of the courtroom or seen outside of the courtroom. You must decide this case only on the evidence that is presented here during the trial. As I told you during jury selection, there will undoubtedly be press coverage of this case. You must not read, watch, or listen to any reports in any form about this case. Now, I am just going to talk to you a little bit about one of your tasks as jurors, which is to determine the credibility of the witnesses who testify, to determine whether or not you believe that the witness is saying, whether you believe the witness is telling you the truth, whether you believe the witness is lying, whether you think the person is being accurate, or whether the person has made an honest mistake. There is no magical test to deciding whether a witness is credible. You bring to this process your common sense, and you make these decisions all the time in your lives when you're trying to decide whether what someone is telling you is accurate and believable. I am going to suggest some of these things you should consider when you're listening to a witness testify. What is the witness's demeanor? Does the witness testimony make sense? Does the witness have a reason or a motive to testify falsely? Is the witness testimony consistent or inconsistent with other evidence or testimony? If there are inconsistencies, are they important and related to important facts, or are they minor? Has the witness said something contradictory at another time? As I said, these are just some of the tests that you use to determine whether a witness is telling you the truth or is mistaken or being accurate. Now, there are 3 rules, because this is a criminal case, that you must keep in mind. First, that the defendant is presumed innocent until the government has proven him guilty. Second, the government has the burden of proof. The defendant has no burden to prove his innocence or to present any evidence. He has no burden to put on a case or to testify. If the defendant does not testify or put on any evidence, you may not hold those facts against him. Third, as I have said a couple of times during the course of these instructions, the government must prove the defendant's guilt beyond a reasonable doubt. I will give you further instructions on this concept later, but this is one of the things that makes a criminal case different from a civil case. A few words about your conduct as jurors. Because you are deciding this case only on the evidence that is presented in the courtroom, that means you may not conduct any independent research about anything having to do with this case. Not with the people that are involved, not with the law or anything having to do with this case. In other words, do not look anything up on the internet. Do not research the lawyers or any witness or the parties. Do not try to find out any information about this case from any source outside of the courtroom. Do not Twitter about it. I am not even aware of all the means of social media, but don't use any of them to communicate about this case, to express an opinion about this case, or to read about other people's opinions about this case. Related to that, you are not permitted to discuss the case with anyone during the trial. Until you retire to the jury room to deliberate and reach a verdict, you are not permitted to talk about the case. That means you can't talk about it with your family and friends, and it also means you can't talk about it with your fellow jurors. And I think I said when you are selected as jurors, that's probably a lot harder, because this is the only thing that you have in common, and it's probably very tempting after a witness testifies to share your thoughts about what the witness said, or to talk about something that happened in court, but you can't do that. If you were to start talking about the case before you've heard all of the evidence and before you've heard my charge on the law, you would be deliberating prematurely, and the law doesn't permit that. So don't talk about the case. None of the lawyers or the witnesses in the case are permitted to greet you or to say anything to you at all. I think I told you this when you were selected as jurors, so don't think they're being rude. They're just not permitted to talk to you. You must report directly to me any effort by any person to influence you improperly or to influence another juror improperly. And related to all this is that you cannot form an opinion about the case until all the evidence is in. Keep an open mind until you start your deliberations at the end of the case. Now, I think all of you have notepads. You may certainly take notes if you wish during the course of the trial, but if you do take notes, make sure that it doesn't interfere with your ability to listen to the evidence. Our court reporters take down everything that everybody says, and if you need to have some testimony read back, you can do that at the end of the trial. So that is the accurate record of the trial. If you do take notes, don't discuss them with anyone before you begin your deliberations. You will not be permitted to take them home with you. They will be collected at the end of each day. And if you decide that you don't want to take notes, that's also completely fine. But you can't rely on anybody else's notes because, as I said, the notes are just for individual juror. As I said, during deliberations, you will be able to request portions of the trial transcript if you need to have your recollection refreshed about evidence. So the last thing I am going to talk to you about is just an overview of the trial. The government will make an opening statement, which is really just an outline of the evidence to help you understand the evidence as it comes in. It's what the government expects the evidence to prove. Defense counsel may, but does not have to, make an opening statement. Again, opening statements are designed for the parties to tell you what they expect the evidence to prove. After opening statements, if the defense counsel chooses to make one, the government will then present its witnesses and counsel can cross-examine them. Following the government's case, the defendant may, but again does not have to, present witnesses or to put on a case. After all the evidence is in, the lawyers will have the opportunity to address you in closing arguments, and after that, I will instruct you on the law, and then you will retire to deliberate on your verdict. So, I think we're ready to begin. Let's begin with the opening statement by the government. You know, I forgot to add one thing that I want you to keep in mind. Oh, child. It may be during the course of the trial that witnesses testify with either a nickname or by their first names. This is not unusual in a case like this that has a lot of press attention, and the witnesses may be testifying to things that are very personal and potentially embarrassing. All right, I'm sorry. Go ahead. So we finally get to the opening statements, and thank God the prosecution was not very long with their opening statements. And so we have Cruz Melendez, and she begins and she says, this case is about a predator, a man who for decades used his fame, his popularity, and the network of people at his disposal to target, groom, and exploit girls, boys, and young women for his own gratification. A man who used lies, manipulation, threats, and physical abuse to dominate his victims and to avoid accountability for years, using his money, his clout, and his public persona to hide his crimes in plain sight. That man, that predator, is the defendant, Robert Sylvester Kelly, more commonly known as R. Kelly. Good morning, ladies and gentlemen. My name is Maria Cruz Melendez, and I am an assistant United States attorney in the Eastern District. These are my colleagues, Elizabeth Geddes and Nadia Shahata. They are also assistant United States attorneys, Special Agent Ryan Shabbat of the Department of Homeland Security Investigations, and paralegal specialist Kara Wintham. Together, we represent the United States in this case. During the course of this trial, you will learn that the defendant has surrounded himself with a team of people made up of dedicated employees and close associates. These people formed the defendant's inner circle. Now, over a period of decades, the members of the defendant's inner circle changed, but at any given point, All of these people had this in common. Their purpose was to promote the defendant's music and brand, that is his public persona as R. Kelly, and to fulfill each and every one of the defendant's wishes and demands. They served him. They were loyal to him. And you will learn that the defendant used that inner circle as his means to a criminal end. Now, in the early 90s, the defendant was an up-and-coming recording artist in the R&B industry, known as R. Kelly. As his success and popularity grew, he put out multiple records and toured around the country. He performed alongside other well-known artists and eventually began headlining his own concerts. And as part of his career, he also began writing and producing music for both new and established artists. What this success and popularity brought him was access to girls, boys, and young women attending his concerts, access to young aspiring artists who hoped for a chance to work with him, and access to fans who looked up to the defendant and jumped at the chance to meet him or just to be around him. And the defendant quickly learned that he could take advantage of his access, and he did. At his concerts and other locations like the mall or the local McDonald's, the defendant had his pick. He had his pick of young fans in cities around the country, eager to meet him, to get his autograph or a picture. And when he found a girl, boy, or young woman he liked, he either approached them himself or had one of the members of his inner circle do it for him. They were given backstage passes or invitations to after parties, and a number where they could reach the defendant or he got their contact information. And once they communicated via phone or text message, he invited them to visit him at his home or at his studio or to travel to see him at other performances. He directed his employees to arrange and pay for their travel so that they could come and see him. And when he had them alone with him, he used them to exert power over them, to dominate and control them physically, sexually, and psychologically. And let's be very clear, ladies and gentlemen, this case is not about a celebrity who likes to party a lot or about the defendant's own private sexual preferences. This real issue here, the reason that we're here today is because, as the government will prove during this trial, the sexual conduct at issue in this case was illegal. It was illegal because in many situations the defendant engaged in sex with minors, boys and girls under the age of 18. Some even in their early teens, very early teens. And when he was having sex with these minors, he often recorded it using video cameras, iPads, or smartphones to produce CP. He also transported some of these girls and women across state lines and sexually fondled them while they were not able to consent and exposed them without their consent to an incurable sexually transmitted disease, an STD or a venereal disease, genital herpes, an STD that he knew for years that he had and was being treated for. And as the government will prove during this trial, he was not able to do these things unchecked for multiple decades on his own without help. See, the defendant created this persona, R. Kelly, and he was at the center of it all, and he surrounded himself with people all at his disposal at his studios and on the road when he was on tour. People like his managers, his personal assistants, bodyguards, drivers, runners. Those are people who ran errands and answered phones, lawyers, accountants, and even unpaid members of his inner circle. But he didn't just use these people to help him with his music career. No, he created and relied on this inner circle to facilitate and to help him cover up his crimes. For example, he directed members of his inner circle to approach young women and young men on his behalf when he wanted to meet them. The defendant had employees and associates give out his phone number to young people that he targeted. He instructed his assistants to book the travel of his victims, including minors, all over the country to see him. He used these drivers, bodyguards, assistants, and runners to keep watch over his victims and carry out the orders that he used to control them. and to try to ensure that his illegal conduct didn't ever see the light of day, he used his accountant and lawyers to pay hundreds of thousands of dollars in hush money to people he thought might go public or go to the authorities. They did all of these things, often without question, at the direction of the defendant. And as you'll hear, sometimes they did these things out of fear of him. Relying on his inner circle, the defendant engaged in criminal conduct over and over again throughout the country over the course of almost 30 years. And as time passed and the defendant committed these crimes without repercussions, his conduct became more and more egregious. He began collecting girls and women as if they were things, hoarding them like objects that he could use however he liked. He'd have them visit him, and eventually he'd have some of them stay with him at his home or at his studio or on the road with him in his tour bus or his Mercedes Sprinter van when he traveled for concerts, also that he could have access to them for his sexual and other needs whenever he pleased. Now, the defendant maintained control over these victims using every trick in the Predator Handbook. First, he targeted minors and vulnerable young adults, picking them out himself or directing members of his inner circle to find them for him. He then got to work grooming them, which you will learn is when someone works to build a relationship of trust and emotional connection with a vulnerable person, like a minor, so that he can manipulate, exploit, and abuse them. In many cases, when the defendant first met them, he would even groom their family members, ingratiating himself with their family or their friends. Sometimes he promised to mentor their careers in the music or in the entertainment business. But then, after quickly reeling them in, he isolated these victims from their friends and family, convincing some of them to spend long stretches of time with him or even more, or move in with him. And as soon as he had these girls and women under his thumb, he instituted a long list of rules that they were required to follow. Rules like he made them call him daddy. He told them never to speak or even look at another man, but instead to keep their heads down if any other man were in the room. He instructed many of them to wear baggy clothing when they were not accompanying him to an event or unless he told them otherwise. He instructed that they needed to come to him before doing anything, causing them to spend hours on end waiting for the defendant to approve some of the most basic requests like permission to leave to go to the bathroom, and leading them to, in some cases, urinate in a cup rather than violate one of his rules. He required them to engage in sex at his direction with whomever and whenever he decided, and he recorded most of these sexual encounters. And above all else, he demanded absolute obedience. And if they didn't follow his rules, if they messed up in some way in his eyes, the defendant made sure that there were consequences. He exacted cruel and demeaning punishments. Sometimes he confined them to a room for days. He physically assaulted them, delivering violent spankings and beatings. And these rules, these punishments, they kept his victims compliant. But the defendant also did what he could to cover his tracks, just in case someone did actually decide to speak out or to, for example, go to the police as insurance, as a way to make sure that these girls and women felt that they could never ever tell anyone about what he was doing. He created and kept collateral on them. He directed them to write letters containing false and sensitive information about themselves, or had them create embarrassing and degrading videos that he could lord over them if any of them crossed him. He photographed and filmed them naked and engaging in sex with him and others at his direction. And he kept this stash of sex videos and photos not just for his own use, but always at the ready if he needed to protect himself by threatening their exposure. And if he couldn't use any of those methods to keep them quiet, he entered into secret settlement agreements, paying victims off so that his criminal conduct couldn't become public. That's the man who sits here before you. That is how he, with the help of his inner circle, operated. I want to talk to you now about the experiences of 6 of the defendant's victims and tell you about some of the specific illegal acts that he committed with respect to these victims. First, I want to tell you about Aaliyah. Aaliyah met the defendant in approximately 1992 when she was about 12 years old. Aaliyah had a gift. She was a talented singer and people thought that she could make it far in the industry. So the defendant began to produce and write music for Aaliyah when she was still a child. And shortly after he began working with her, the defendant began to engage in sexual activity with her. And for years, while Aaliyah was a minor, too young to even consent to sex, he continued to engage in activity with her that lasted several years. One night in 1994, when the defendant was on tour, he got some news about Aaliyah. She thought that she was pregnant. This, of course, was a huge problem for him. Why? Because at the time, Aaliyah was only 15 years old, and if she was pregnant, that meant that there would be questions, a lot of questions. At the very top of that list of questions would be, who is the father of that baby? So the defendant and his circle came up with a plan that the defendant thought would keep Aaliyah from talking and a plan that would keep him out of jail if anyone found out. His plan, the defendant decided that he needed to marry Aaliyah. That way, as far as he understood, if anyone found out about the pregnancy, about his sexual activity with her, Aaliyah could not talk. In other words, if she's his wife, then she can't testify against him, or so he thought. Now, as I said, the defendant is on tour at the time and about to go on stage for a concert. In fact, he's got other appearance dates as part of this tour over the next few days, but he's got to get this done and fast. So he flew home to Chicago in the middle of the night with a few of his most trusted friends and employees. When they land, Aaliyah was awaiting for the defendant at a hotel airport. At an airport near the hotel, and the defendant and his crew got to work. Aaliyah went to the hotel and they had a meeting there, and they got to work gathering what they needed to make this marriage happen. But there was a problem. Aaliyah was 15 and she needed an ID showing that she was over the age of 18. She needed that in order to get the marriage license. So the defendant and his tour manager decided to bribe someone that the manager knew at a local public assistance office who gave Aaliyah a fake ID that she could use to get the marriage license. And that's exactly what they did. The defendant, Aaliyah, and his tour manager drove to the public aid office. Aaliyah and the tour manager went inside. The tour manager paid one of the employees at the public aid office about $500 and they walked out with a fake ID for Aaliyah. They made a few phone calls and lined up a minister to officiate the wedding. And in that hotel suite, the defendant, a 27-year-old man, married Aaliyah, a 15-year-old girl. And with that taken care of, the defendant flew back to where he had been to finish his concert tour. Here comes Judge Donnelly. Miss Cruz Melendez, I am so sorry. I have to interrupt you. May I see counsel at the side with the court reporter for just a minute? Just one lawyer from each side. Fine. Sorry about that. Okay, here comes Judge Donnelly with this sidebar. So see, she was getting started early, so we should have known what to expect. So this goes in the category of things I don't know why I'm hearing about it, but apparently your witness wants to watch the opening statements. Geddes, yes. Donnelly, that would ordinarily be a thing that you should check with me before, because counsel may have some objections. Canick, I definitely have an objection to that, Your Honor. Donnelly, it is not a good idea. Geddes, I apologize, Your Honor, but I spoke with Mr. Farinella last night and I advised him of this and he indicated he did not have an objection to it. Canick, may I have a word? Donnelly, sure. So there's a pause in the proceedings and then Canick comes back. Your Honor, it's my understanding that Mr. Farinella was under the impression, after speaking with the government, that the witnesses were entitled to be present for the opening. I told him that's not the case, and I believe we will object to it. I am going to ask the witnesses now be precluded from continuing to hearing the open remarks. Donnelly, I don't think they're listening to it. Canick, they're not. Okay. Donnelly, no. Generally, we don't have witnesses in the courtroom for proceedings that don't involve them. I don't know that there is a blanket prohibition against it, and it is certainly a subject for cross-examination, but it is just generally not done. And if it is something that you're contemplating, you really should raise it with me. Geddes, I apologize. Donnelly, so there is an objection to it now. I am quite confident that Miss Geddes was clear. I don't think that was a hypothetical suggestion, so Canick, I think it was misheard. Donnelly, misheard, that's exactly right. While I have you at the side, I am also told that the guy who runs press at your office, I can't think of his name, Geddes, John Mazzulli. Donnelly, that he alerted all of the reporters that he will have exhibits in a Dropbox. It is probably fine, but this is not his show. Geddes, I understand. Donnelly, so if anything like that is going to happen, obviously nobody can look. The press is entitled to look at the exhibits once they come in, but that's something that really should be done through the court. So I am going to ask you to instruct him not to do that again. Geddes, yes, I will. And there are plenty of exhibits we have an issue with. Just for the record, I want to just let everyone know that we found out late last night that this witness was insisting on attending the opening statements, and is under the Crime Victims' Rights Act, which says that a victim witness, as opposed to another witness, has a right not to be excluded. Candidly, this was not the government's choice, and we understand the obvious cross-examination avenue, but I think it is the government's position that under the act, she does, in fact, have the right to attend. But that's why we wanted to put everyone. Then Canick cut her off and said, is that an absolute right or discretionary? Does the court have discretion on it? Donnelly, no, I think it's an absolute right. Geddes, I think it's an absolute right as well. It wouldn't be for a normal witness, and we have advised every other witness who plans to testify that they cannot attend the proceedings, with the exception of our case agent, which is permitted under the law. But I think because she is a charged victim in this case, one of the rights protected under the act is the right not to be excluded. And my understanding under the law is that includes even if she is a testifying witness. Donnelly, she can attend if there is room for her in the overflow room. There are limited seats in there, so you can cross-examine her about her attending it again in the future. Geddes, yes, Your Honor. Donnelly finishes her statement. Always good to know about these things ahead of time. Canick, which witness is this? Child, we should already know it's Ariel. Well, at least that's who Donnelly thought it was. She said number 5. And then Geddes said, no, it's not. It's Geronda Pace. She's our first witness. Canick, oh, Geronda Pace. Thank you. Donnelly, okay. And then the sidebar concludes. And then they're back in open court with the jury present. And then Donnelly says, okay, I apologize to Miss Cruz Melendez. I apologize to the jury. I wouldn't do that if I didn't have to tend to some matter. So we're all set. Go ahead. And then Cruz Melendez continues. Thank you, Judge. Next, I want to tell you about Stephanie. When Stephanie was only 16 years old, she saw the defendant while she was at a local well-known McDonald's known as the Rock and Roll McDonald's. She was there with her boyfriend and some high school friends when the defendant eyed her. When Stephanie went up to the counter, the defendant sent one of his associates over to her, who gave her a piece of paper with the defendant's telephone number written on it, and he told her that the defendant wanted Stephanie to call him. She told the associate that she was only 16 years old, and the defendant's associate said, "That's okay." Stephanie ultimately decided not to call the defendant, but about a year later, in 1999, when Stephanie was 17 years old, she heard that the defendant was making an appearance at a Nike store close to her summer job where she was working as a barista. She went to see him because she wanted to tell him about a friend of hers who was an inspiring singer. The defendant told Stephanie that he remembered her. She asked the defendant whether he would be willing to meet with her friend to hear her sing. The defendant agreed to see Stephanie's friend, but said he wanted to meet up with Stephanie first. And again, he gave Stephanie his telephone number. Stephanie was only 17 years old at the time. The defendant was 32. Just a week or two later, the defendant began having sex with Stephanie regularly for approximately 6 to 8 months. Stephanie's friend eventually did sing for the defendant at his studio, but he wasn't interested in that. What he was interested in, what he wanted, was to continue having sex with Stephanie. He'd have Stephanie come over to his studio to meet him, where she would wait in one of the rooms there for hours, and whenever he was ready, he would go into the room where she was waiting and he'd have sex with her, or he paid for her to travel out of state to meet him so that she could have sex with him. He told her to call him daddy and became controlling, directing her not to even speak or look at other men, making her afraid of the consequences if she did not do everything that he instructed her to do. On one occasion, while Stephanie was still a minor, the defendant told her he was picking her up from the studio where she had been waiting for him to bring her to his house to make a movie. Once they arrived, the defendant used a video camera to record a VHS tape of Stephanie having intercourse with him. Next, I want to talk to you about Sonia. Now, Sonia met the defendant outside of a mall in Salt Lake City, Utah. In 2003, when she was 22 years old, Sonia was an intern at a radio station and heard that the defendant was at the mall. So she headed over there with a friend, thinking that it would be great for her position as a radio station intern, so that she could get an interview with the defendant while he was still in town. When she got there, the defendant didn't give her an interview, but he or one of his associates did slip Sonia the defendant's number. Still hoping to land the interview with the defendant, Sonia called the number to see if she could set up a meeting with him. After some time and several calls later, the defendant invited Sonia to his studio in Chicago. One of the defendant's employees arranged her travel, and she flew to Chicago to meet with the defendant in the hopes of getting that interview. When she arrived at the studio, it was nothing like she expected. One of the defendant's employees asked her if she needed condoms. Taken aback by the question, she said no, that she wasn't there for anything like that. One of the defendant's employees then escorted her to a small room, went through her luggage and phone, made copies of her ID, told her to sign a non-disclosure agreement, and left. Alone in the room, she soon discovered that the door was locked, and despite her knocks on the door and calls to the front desk, no one let her out to leave. Sonia spent approximately 3 days in that room pleading to be let out, to go home, to get some food, to be able to go to the bathroom. But what she heard from the defendant's various employees that were enforcing his instructions was that they needed authorization from the defendant first to let her leave the room. The few times that she was actually allowed to leave the room to use the bathroom, she was generally escorted by one of the defendant's employees. Days went by, and finally one of the defendant's employees brought Sonia some cold Chinese food and a Coke. After taking a few bites and drinking the soda, her eyes grew heavy and she fell immediately to sleep. Sonia woke up to find her underwear had been taken off and felt a wetness between her legs, and made it clear to her that she had been abused in some way while she was not conscious. She also saw the defendant in the corner of the room doing up his pants. Confused, she stood up to speak with him. He grabbed her backside, pulled her towards him, and said he had to go. He then left. That was the first and only time that Sonia saw the defendant on that trip. Only then did one of the defendant's employees come and say that they could let her leave, but not before telling her that she could never speak about what happened there to anyone, and taking a list of people, including her grandmother's name, who were close to her. All of this she took as terrifying threat that keep quiet or else, and it worked. She did keep quiet for almost 16 years. Now I want to tell you about Geronda. Geronda first met the defendant in 2009 when she was only 16 years old. At a party at the defendant's house in 2009, the defendant was 42. Geronda was a huge fan of the defendant's music, and when she met him at that party, she naturally was excited to be talking to him. And while they were talking, she told the defendant that she was 19, which wasn't true. On that night, she and the defendant exchanged phone numbers, and just a few days later, the defendant invited Geronda over to his house. And when she got there, after some conversation, she told him that she was a virgin. He told her that he wanted to train her, to teach her how to give oral sex, and that's how it started with oral sex. Soon after, the defendant and Geronda had sexual intercourse. Now, shortly after the defendant began having sex with Geronda, Geronda told the defendant her true age. She told him that she was actually 16 years old. She even showed him her ID card. She told him that she was actually 16 years old, and that what did the defendant do? He didn't ask her to leave. He didn't say, we can't see each other because you're a minor, because you're 16 years old. He shrugged it off. He asked her, what's that supposed to mean? And instructed her to just continue to tell people that she was 19. And for the next 6 months or so, the defendant continued to have sex with Geronda, a 16-year-old girl, too young to consent to sex regularly for the better part of a year. At times, he video recorded sex with Geronda using a video camera or an iPhone. The defendant also became controlling, making her follow a list of rules, and he became violent with her. At one point, the defendant even instructed Geronda to write and signed a letter that he could keep as insurance policy of sorts, containing false information saying that she worked for him, that she had stolen money and jewelry from him, and that her parents told her to get close to the defendant. On one occasion, one of the several times that the defendant became angry with Geronda, he slapped her, choked her, and threatened that the next time it would be even worse. And then the defendant, while Geronda was shaken and upset from the beating, made her give him oral sex. That was the last day that Geronda was with the defendant. I'd like to talk to you about Zell. Zell first met the defendant when she was 17 years old in 2015. He was 48. She had gone to one of the defendant's concerts with her mom and dad, and during the show, one of the defendant's associates gave her a wristband so she could come up and stand near the front of the stage. During the show, the defendant paid extra attention to her, singing some songs directly at her, and then one of his associates gave her his number and told her not to say anything to anyone. After the concert, Zell began to communicate with the defendant. Now, Zell initially told the defendant that she was 18. She was a serious singer, performing in choirs and even doing some paid gigs. She thought maybe the defendant could help her with her career. The defendant told Zell that she should come and audition for him, thinking that this could be her big opportunity. Zell headed to meet the defendant one day after her high school extracurriculars. He told her to swing by the hotel where he was staying. So she met him on his Mercedes Sprinter van that was parked outside the hotel. Once there, he asked her to sit on his lap and give him a kiss. She was unsure, but she did what she was asked. The defendant then asked her to meet him upstairs in the hotel room. She did. When they were alone in the room, Zell asked if it was time for an audition. The defendant told her before he could hear her sing he needed to relieve himself. It was clear what he meant. He wanted to relieve himself sexually. Not wanting to do anything with the defendant, Zale tried to politely decline. None of it fazed him. He continued to hound her for some form of sex, telling her that he wanted to perform oral sex on her and that if she lets him, he'll take care of her for the rest of her life. Finally, reluctantly, she let him. Eventually, she got to sing for the defendant. After that, the defendant spoke with Zale and he invited her to travel to various shows around the country where he was performing or to visit him at his home in Chicago, directing members of his inner circle to arrange travel for her. During these trips, the defendant continued to engage in sex with her, video recording the sex most of the time. Still, the defendant talked to her parents about how important it was for Zale to practice and learn the business and telling him that he could help her with her career. And under the guise of mentoring her, telling Zale that she was going to be the next Aaliyah, he invited her to travel with him while he was on tour, all the while continuing to have sex with her. After spending all summer with the defendant on tour, when the time came for Zale to start her senior year in high school, she told him that she was in fact 17 years old. Did he end it? No. He suggested that she do her senior year remotely and live with him full time. He continued to have sex with her in various locations around the country despite the fact that she was a minor and too young to consent to sex. And the defendant not only had sex with Zale when she was a minor, but he also exposed her to an STD, genital herpes. Years earlier, the defendant was diagnosed by his doctor with herpes, an incurable STD. His doctor told him that he had the disease and that he needed to disclose that fact to his sexual partners and to practice safe sex. But the defendant never told Zale that he had herpes. As you will learn during trial, ladies and gentlemen, this is a crime in both New York and California, two of the places that the defendant had sex with Zale. And as you will learn, herpes is an incurable disease that can cause serious and permanent bodily injury. And if you know you have it and the defendant was well aware that he did, the law requires that you disclose that fact to your sexual partners so that they can consent to having sex under those circumstances, but the defendant never did. Over the next 5 years, Zale traveled and lived with the defendant, and throughout the defendant sexually, physically, and psychologically abused Zale. As with other girls before her and after her, the defendant subjected Zale to his strict rules, instructing her to call him daddy and prohibiting her from doing even the most basic of things without his authorization. And as he did with other girls and women he targeted, he punished her severely when she broke his rules, giving her violent beatings that he called chastisements to teach her how to behave and how to follow his rules. For some time, these chastisements happened every day. Sometimes the defendant forced her to have sex with a man that she had never met before as punishment for breaking one of these rules. On multiple occasions, he confined her to rooms for days without letting her leave. I'd like to now talk to you about Faith. Faith met the defendant in 2017 backstage after one of the defendant's concerts in San Antonio, Texas. Faith was 19, the defendant was 50. Two of the defendant's associates approached Faith after the concert and gave her and her half-sister wristbands to go backstage for a meet and greet after party. When Faith got backstage, there was a party of about 30 people, and everyone at the party, except for the defendant's employees, were women. After watching her dance, the defendant approached Faith, handed her his number, told her to take it but not to tell anyone that he had given it to her. Faith called the number and the defendant and she began communicating. Faith called the number and the defendant and she began communicating. Within a week, the defendant told Faith that he loved her, invited her to come see him, and told her that she could contact one of his employees to make her travel arrangements. Now, eventually, at the defendant's invitation and completely on his dime, Faith began traveling to various locations around the country to see the defendant, and he began a sexual relationship with her, sometimes recording the sexual activity on an iPad. On one of these occasions, when the defendant had one of his employees arrange travel for Faith to come and see him, the defendant brought Faith into a small room and he told her to take off her clothes. In the room, in her view, right by the defendant was a gun, which the defendant placed nearby. He then began to ask her a series of questions and told her that there would be consequences if she lied. Scared by the situation, believing that she could not leave even if she wanted to, Faith did what the defendant asked her to do, including when he directed her to give him oral sex. Now, when she traveled to see the defendant, including in New York, as was his practice, he engaged in unprotected sexual intercourse with her, never disclosing the fact that he had previously been diagnosed with herpes. And when Faith sued him for exposing her to herpes, the defendant and others on his behalf threatened to expose compromising photos and videos of her that he had in his possession if she didn't cease her lawsuit or stop speaking publicly about the defendant. For all of this conduct, the defendant is charged in a federal indictment with multiple crimes. First, he is charged with racketeering. You're going to learn more detail about racketeering as is at a later point in the trial from Judge Dunley. But what it essentially means is that the defendant is charged with committing a pattern of multiple crimes spanning almost 3 decades as the leader of an enterprise which you will learn more about, as well as another word for a group of people working together to carry out a certain purpose. Here, the defendant and his inner circle, together with the defendant at the center of it all, they form the charged enterprise. The racketeering activity that the defendant is having charged with committed by using his inner circle includes conduct related to the 6 victims I told you about earlier. When I described to you some of the experiences of the 6 victims, I explained that some of the victims, like Aaliyah, Stephanie, Geronda, and Zale, were minors when the defendant began having sex with them. The charged racketeering activity related to those victims include bribery, sexual exploitation of children by producing child porn, forced labor, and illegal transportation, coercion, and enticement of minors from the purpose of engaging in illegal sexual activity, including sex with minors, and illegally failing to disclose his herpes to his sexual partner before having unprotected sexual intercourse. Some of the other victims, like Sonia and Faith, were over the age of 18. The charged racketeering activity related to them includes kidnapping, forced labor, and illegal transportation, coercion, and enticement of these individuals for the purpose of engaging in illegal sexual activity, including aggravated abuse and illegally failing to disclose his herpes to a sexual partner before having unprotected sexual intercourse. The defendant is also charged with 8 other separate crimes related to the defendant's transportation, coercion, and enticement of Zale for the purpose of engaging in sex with her while she was a minor, as well as transportation, coercion, and enticement of Faith to engage in unprotected sexual intercourse with her without first disclosing to her that he had contracted herpes. Now, during the course of the trial over the next few weeks, the government's going to present evidence to you that will prove these charges beyond a reasonable doubt. So how will we prove these charges to you? What is the evidence? First, you're going to hear from many of the defendant's victims themselves, who will tell you the many different ways the defendant exploited them. You will also hear testimony from various former members and associates of the defendant's inner circle. People who work for the defendant, such as his personal assistants, managers, and runners, as well as people who were his close associates going back all the way to the 1990s and as recent as 2018. People who the defendant used to facilitate his crimes. For example, by directing them to arrange travel for his victims throughout the United States, including right here in the Eastern District of New York, and using them to enforce the defendant's instructions that he used to control almost every move of his victims. You're also going to hear from expert witnesses, including a clinical and forensic psychologist. She will testify about how the methods used by predators to target and groom vulnerable people like minors and young men and women. She will also testify about the effects of violence in relationships and the associated trauma with those relationships. She will explain why victims often stay with their abusers and delay reporting acts of abuse and violence to law enforcement. You will also hear from experts who will tell you that the defendant's DNA was found in semen recovered from a t-shirt by one of the victims when she was just 16 years old. In addition, you will see, I think they mean here, evidence such as official documents like birth certificates for the victims and the documents proving that the defendant did marry Aaliyah when she was just 15 years old. Text messages showing that the defendant demanded total obedience, that he had members of his inner circle stand guard over his victims when they were on punishment. Telephone records showing contact between the defendant and his victims, including while they were minors. You're going to see travel records that show the victims traveling to location around the country to see the defendant. Medical and prescription records regarding his treatment for the disease that will be explained during the testimony of the defendant's primary care physician regarding the defendant's herpes diagnosis. You're also going to see physical evidence obtained by law enforcement from searches done pursuant to search warrants authorized by a judge, the defendant's own apartment and storage facility. For example, you'll see decades-old paper phone messages recording calls from his victims. You'll see video and audio recordings that the defendant made himself or instructed victims to make that show the type of control that the defendant had over his victims and the demeaning punishment he forced them to perform if they broke his rules. Some of these recordings may be difficult to listen to and to watch, but we will be presenting this evidence to you to prove the defendant's pattern of illegal sexual, physical, and psychological abuse. You're also going to see letters the defendant kept containing false and embarrassing information, which the defendant directed his victims and others to write so that he could have them in his back pocket in case anyone attempted to accuse him of wrongdoing. You will see records such as settlement agreements showing that the defendant tried to pay millions of dollars to keep his victims silent. Witness after witness, exhibit after exhibit, you'll have the chance to hear and see all the government's evidence. Now, because of the nature of trial, some of the evidence may be presented to you in a way that's not always in complete chronological order. But by the end of the presentation of evidence, you will see how all the government's evidence fits together to prove each and every one of the charges in this case. And after we presented all this evidence to you, after you heard from the witnesses and seen all the exhibits, the government is going to have an opportunity to come before you again and review all of that evidence with you. And at that time, we're going to ask you to hold the defendant accountable for years of engaging in sex with minors, creating CP, and otherwise sexually abusing girls, boys, and young women. Accountable for using bribery, lies, fear, and extortionate tactics to keep his victims and other potential witnesses silent. We will ask you to reach the only verdict that is consistent with all of that evidence, and that is a verdict of guilty on all counts. Thank you. Child, so then Judge Donnelly said, "Thank you, Ms. Cruz Melendez." And then she asked if the defendant wished to give an opening statement. And then Canick said, "Can we have a break?" And Donnelly said, "Surely, we'll have a break for about 10 minutes. Please don't talk about the case at all. And we'll see you in just a few minutes. Thank you so much." Okay. And so we're at like an hour and a half. And I am going to go ahead and read to you guys a summary, if I can get the file to open. Okay, wait a second. I'm going to read to you guys a summary of what all pretty much has happened. Just bullet points, not everything that's happened, because we would be here for another week. But I am going to read some case notes that, from over the past few weeks that I was able to gather. And we are going to start from day one, I believe. Wait, hold on a second. Let me get my stuff together. Okay, so the first witness was Geronda. And so basically Geronda admitted that she was a super fan. She admitted that she skipped school, lied to her mom so she could pursue R. Kelly. She was considered a groupie, or groupie was the term that was used to describe her. And then her story expanded, with lies getting bigger and bigger, and she was attaching more to the interaction between her and R. Kelly than actually took place. Like, in her mind, they were really in a relationship. We know that Geronda ended up, even though she had stalked him at court, we know that she ended up actually meeting him after meeting Kelly's friend Ruby Chris on MySpace, and he ended up inviting Geronda. It came to a party. She went to the party. We found out that she gave he goes by Bubba, but his social media is Ruby Chris, and she ended up giving him $4,000. And then there was a witness who testified, who was an expert witness. And the way that the prosecution was setting up this witness, it was so confusing. But on that video, I posted a comment. I pinned a comment from one of the people who was watching that video, who was able to break it all down. And so what she figured out was, in all this testimony that the prosecution was reading, that the witness never got to detail or explain. And that was pretty much that Geronda's mom was somehow in on whatever was going on. There were telephone conversations between Geronda, her mom, and Kelly at some point. And then we know Bubba, whose real name I think is Jermaine Maxey, his phone number was included. So it was just like a whole bunch of mess was going on with that situation. And I think that Geronda was the one that had the blue Aristotle polo type shirt with the semen on it, and it was proven to be R. Kelly's semen. But then I think the defense could have did more to explain that Geronda knew people who were still in relationships with R. Kelly, and that she could have very well gotten that shirt from them, that it wasn't necessarily a shirt that she got when the two of them were in this dramatic fight that she, was telling to the courts that happened, where he slapped and spit on her and all this other stuff. So then we had Jane Doe number 2, who was Stephanie. And she claimed that they dated, for 2 months. She came to see him, that there was a point where she got on a plane. She said that no one forced her to be in this relationship. She said that, wait, hold on a second. I think I got my notes mixed up. Okay, Geronda was the only witness to testify. I was reading some of the notes from the defense's opening statements in there. But anyway, Geronda was the first person to testify. And then on day 2, they ended up dismissing one of the jurors, one of the alternate jurors, alternate juror number 3, and that person was asked to leave because her employer said that they would not pay income or benefits if she continued to serve on the trial. And so it really didn't impact the makeup of the actual jury. She was one of the alternates, and so she was just let go, and they had plenty of alternates, and so the jury remained intact, which was seven men and 5 women, I believe the jury is, or vice versa. And so the day started out with the direct examination of Geronda, who was still on the witness stand, and she kept saying that he recorded them having sex. And then she told the story about him wanting her to dress as a Girl Scout and wear her hair in pigtails. Like, who the hell is using the term pigtails in 2021? And then she let them know that she had his name tattooed on her body. And she never did explain why she had the tattoo done, but she had the tattoo done. And then Canick began to cross-examine her. And Pace, Geronda sounded very confident and maintained her composure, like the psycho that she is. But anyway, the defense did score points later in the day by showing photos of Geronda at Kelly's home and in his presence wearing tight-fitting clothing, because she said she had to wear the baggy clothing, and she had on these tight-fitting clothing. And then remember, she said she was locked in the room and couldn't go to the bathroom for numerous days. And there was a picture of her laying in the bed in these tight clothes, looking up at a mirror, because she was in the mirror room. And there was a bathroom actually in that room. And then they introduced the settlement agreement, in which Geronda agreed that she had told Kelly that she was 19 and showed him a fake ID. And I believe a copy of that fake ID was found in the storage unit, and that was introduced later. And the defense also learned during cross-examination that Geronda wanted to go back and get back with Kelly between and during 3 separate lawsuits that she had filed against him. And they introduced a 2019 transcript in which Geronda told the government, that the defendant had talked to her about herpes in 2009, saying, quote, "Daddy is not doing too good," end quote, and that he even checked Geronda's personal area to see if she had herpes, and it refuted her claim prior to testimony during the trial that he had never told her about the herpes. And then the most emotional part of her testimony was when she began crying, reading her journal, which we later found out that the journal was created after she filed the lawsuit, that the lawyer told her that they thought it would be a good idea for her to write this journal. And so that was when she created the journal. And then after Geronda got out the stand, they called witness number 2 and number 3, and that was an Olympia Fields police officer, and then the Dr. Chris McGrath. And so the police officer testified that he responded to a 2009 missing juvenile call at Kelly's home, and it turned out to be then 17-year-old Dominique Gardner. Her mother had called in this missing person call, and the officer testified that someone at security referred him to the business manager, who told him that the girl was asked to leave after learning of her age, and that Kelly had no further contact with Dominique after learning her age, and that it is important to note that Dominique and Geronda had previously been in a romantic relationship during the testimony, and that Dominique and Geronda Geronda had Dominique's name tattooed on her body along with their anniversary date. And then the Chris McGrath, when he took the stand, He said that he had been Kelly's doctor for 25 years, and he testified about treating him for various STDs starting in 1995, including chlamydia, gonorrhea, and herpes. And he treated Kelly so much that he had memorized the number for the pharmacy where he called in medications for him. But he believed that he had not treated Kelly for herpes until 2011, though he did treat him for other STDs earlier. And that this was important because, according to Geronda, she contracted herpes from him during their 2009-2010 sexual contact. And then at the end of the day, the court dismissed. That was when they dismissed the alternate. And so now they're down to the jurors, 12 jurors with 5 remaining alternates. And I think all the alternates were women, but they only come into play if they have to replace someone who is actually on the jury. Okay, so then on day 3, which was August 20th, and I believe I began picking up, like, reading the transcripts on... let's see, 18, 19, 20, like the 23rd, I think is when I began reading the actual transcripts. I didn't read the transcripts for these days, but I'll probably go back and do it over the next couple of days. So on August 20th, there was a testimony from Anthony Navarro, who was a former employee of Kelly's, and he pretty much corroborated some of what Geronda testified to. Then there was the Cook County Clerk's Office supervisor verifying the marriage documents for Kelly and Aaliyah. And then Demetrius Smith took the stand. And so the day began with the government calling the Anthony Navarro. He was a former employer who worked for Kelly from 2007 to 2009. Signing an NDA. He had to sign an NDA as a intern, I believe is how he started. He testified that he picked up food for Kelly and his guests, who he described as mostly girls, drove them around and ran errands. He testified that he was not allowed to speak with any guests, and that was one of Rob's rules for us. He also testified that the girls were supposed to stay in designated rooms, and if they were caught outside of those rooms, he asked them why and alerted Kelly or a manager. He said on direct examination that the girls, they had to get permission for most things, like if they wanted food. However, on cross-examination, he clarified that he did not have to unlock rooms to let people in and out, that there were regular doorknobs on the doors, and while some people could not leave due to transportation issues, they were free to walk off the premises. He also went back and forth on how young the girls appeared. On direct, he testified the girls who crossed into the property looked really young, and we learned that those were Geronda and her friend Kiona. He said that no guests appeared to be underage and seemed to be his age, which was 21 or 22. Then they had redirect of him, and he said that working for Kelly, that it was weird. It was a weird time for me. Things you had to do was just uncomfortable. And he said that it was like working in the Twilight Zone, and that you just went into and he also said that you just went into the gate and it was like a different world. And then they brought on Courtney Wilson. Courtney Wilson was an associate attorney for Susan Loggins, who handled a couple of the lawsuits for Geronda Pace, and that Geronda hired her in 2010. Her testimony was very short, and she just basically talked about Geronda coming in, them taking her information, and that she was told about the t-shirt with Kelly's semen on it, which she used to wipe her body. And then on cross-examination, the defense brought out that the memo did not note that they had the t-shirt. And let's see. Then the next witness was someone named Carolyn Harris, and Carolyn Harris worked for the supervisor of the Cook County's clerk office, and she basically went over the process. She wasn't working there at the time the alleged marriage took place, but she went over the process of how you get the marriage application, the license, the certificate, and basically she verified that the documents which indicated that Aaliyah's birth date was 1/16/76 and that she was 18 years old, and she just pretty much, she wasn't the physical person involved in any of this. She was just basically reading over what the records stated and how the marriage license was definitely signed and returned, and that a marriage certificate was issued. And so the debate came up, amongst fans and supporters, because there's still this belief that this whole marriage was a publicity stunt. And so what the belief is that the guy who they brought in to perform this ceremony, that he didn't actually mail the certificate back in, but that it was Barry Hankerson who actually mailed, that it was Barry Hankerson's idea, and it was supposed to have been a publicity stunt for the album release, which was Age Is Nothing But a Number. But then somebody decided that this would be a good way to kind of like control R. Kelly, to get him to turn over all of the masters and the production, to sign everything over to Barry Hankerson, was to file this license and somehow hold it over his head all these years that they had filed this license and this marriage took place. And I guess that he could come forth at any time and talk about it. But interestingly, Barry Hankerson wasn't called to testify in this case, nor was Aaliyah's mother called to testify. So we still don't know what the truth is behind this marriage. So then after that, Demetrius Smith took the stand, and you guys just have to go and read my commentary, listen to my commentary on Demetrius, because Demetrius just acted a pure D fool on that stand. And I believe I'm just going to go ahead and do the video from the actual transcript. But in my commentary about what took place in court that day, it's pretty detailed on all the foolishness that Demetrius did and the way he acted. And actually, I may have already read Demetrius' transcript. That might have been the video, but I'm not going to go into the details here because there's another video out there that pretty much explains what was going on that day. So then on day 4, that's when Azriel took the stand and started telling her web of lies and what was going on. And I believe I did the transcript for Azriel as well, and you guys can go and check that out. Demetrius finished up on the morning of the 4th, and then Azriel took the stand and told her story. Then on day 5, there was a former girlfriend. No, day 5 was still Azriel. And so she continued. I believe Azriel was on the witness stand longer than everybody. So day 5 was Azriel, and she was talking and saying, her story. And then on day 6, Azriel was still on the stand, finishing up, and she was talking about, he made her lie about the Gayle King interview 2 months after the release of Surviving R. Kelly, and how he was in the room coughing. During cross-examination, Deborah Koenig grilled her about her parents' possible motives and how they was trying to get this dildo in production that played his music once it was in use, that played R. Kelly's music once it was in use. Then he asked her about lying to police about her age and what happened on the first day she met him. And then she read letters reminiscing about good times with Kelly, including a time he staged $500 worth of Red Lobster in a room and played music for her. And then, let's see, day 7. And also Azriel's best friend testified on that last day that Azriel was on the stand, which was day 7, because Azriel was on the stand for 3 days. And so she finished up her testimony, and then the friend testified about, things that she knew about the case. And then one of R. Kelly's friends testified, a guy named Keith Williams, and he got emotional during his testimony, and he talked about how he was the one that got the preacher, the Nathan Edmonds guy, to perform the marriage ceremony. Then experts came back with the t-shirt that Geronda presented, and that had, and I guess they verified that it was his saliva and semen. That okay, so it came back inconclusive about the saliva, but then I guess it was his semen that was on there. Let's see what happened on day 8. Day 8 was when Richard Arline testified, basically saying that he was lured to Kelly's home under false pretenses, and about a time that he was performing, that he was in the garage or something, and the garage had been turned into a boxing, child, had a boxing ring, and the girl came from under the boxing ring to perform oral on him. Day 9 was Faith started her testimony, and I read the transcripts for Faith's testimony. And then Suzette Mayweather also testified that she was an assistant, and that she recalled Kelly reprimanding her for letting a female guest leave to use the bathroom without his permission. And he also sent her on a bizarre midnight run to buy him some Miss Patty's pies, and how she bought all the pies in the store. Then on September 1st, which was day 10, Jane Doe number 6, which was Faith, was all still on the witness stand, and she testified about her relationship and about the whole gun issue. And then following Faith, it was Faith's mother testified, which I really had no problem with Faith's mother testifying. And Faith's mother, I can say consistently, has stood by her daughter, not on the BS like the Clarys, but she has supported Faith religiously throughout this whole whatever was going on. And then the Nathan Edmonds guy testified, that he did perform the ceremony. He didn't know who R. Kelly or Aaliyah were, and that he did. Then he was shown the marriage license, but I think he may have said he never sent it in, and that's what's leading to the speculation that it was actually Barry Hankerson that sent the thing in. But it was received by the Clerks County office, and they did enter it, which did certify the marriage. And then on the 11th, that was when what was the girl's name that testified? Oh my God, I can't even think of her name, but she was 31. And she said that she was 15 in 2006 when her relationship began with him. And she talked about the backstage passes. Addie, I think that was her name. Addie somehow ended up in some mess, and I read her transcript, I believe. And she talked about, free flights, going to the hotels. She described threesomes with him and wearing lingerie, and she was instructed to walk. No, this was Alexis. And that she had to walk the girlfriend who was on her hands and knees wearing a leash and collar. The defense did not cross-examine Alexis. So then on day 12, they heard about the $200,000 settlement that he had with, oh my God, what was that girl? Katie. And she was the one with the friend who had died. But even after she did the settlement, she still wanted to go back and see him. But he was like, hell no, because you done sued me and got $200,000. We're going to keep that non-disclosure intact. And also she claimed he infected her in 2001, but she didn't sue him until like 2004 or something like that. And then on September 8th, which was day 13, that's when we heard from, I believe it was Sonia. And so Sonia was the radio station intern who said that she wanted to get this interview. He wouldn't interview her in Utah where they met, so she ended up flying to Chicago, and she claimed that she was locked in the room. But she had her phone. She was able to talk to her mom and friends the entire time, but she claimed she wasn't able to leave, and she never, asked for help or called the police, even though she had the phone. And that whole story was really weird. And I also did the transcript on that. So you guys can go and check that out. And let's see. Once again, I have lost my place. The page just be scrolling and going wherever it wants to. So then on September 9th, did it again. On September 9th, Sonia continued her testimony. And then we heard from Diana Copeland, who was an assistant of R. Kelly's. And she pretty much said that she didn't see anything odd. And she reiterated and also did an interview with Good Morning America where she was like, this man is a celebrity, he's wealthy, that you just can't be roaming around his house, and that a lot of the rules and everything that was in place for security. He had people on the premises, celebrities. He didn't want these people running up to the celebrities and harassing or bothering them. And so all the rules that were in place for a reason. And then she talked about how she did all of the travel, how she, ordered the Ubers, went shopping with them. And basically, just talked about how the girl, she never heard him tell them not to look at men, but she did think that their behavior was strange when they were around men, and you could surmise that that was because of something that he had told them. And then Canick tried to get her to confirm that daddy is a term of endearment. And I believe Judge Donnelly cut that off and said that he couldn't proceed. And then he also asked her about lyrics to the song Chocolate Factory, in which Kelly refers to himself as daddy. And Copeland said that she was unable to recall the lyrics to the song. And when asked why she had to knock before exiting the tour bus bathroom, she said it was because the door was located across from the bus's microwave oven, and that someone could be walking by the door with hot food or water, and that was why they had to knock. And she also testified that she never served Jane Doe number 6, which is Faith, alcohol, nor did she ever sit outside the stall while Faith was using the bathroom. And she testified that Kelly's team implemented a female-only Uber driver rule for safety reasons. And that also makes sense because if you guys remember, Lyft actually implemented some kind of policy where, if they got calls or if there was a request for drivers late at night, it had to be a female, or the people could request a female. And that sexual assault cases amongst Uber and Lyft drivers is very, very high. And then there are rideshare companies that are geared towards women. So that made a lot of sense. And then Diana Copeland also talked about how she used to write the text messages for R. Kelly up until text to talk was created, and then he was able to do texting by himself because he could just talk into the microphone. And so she had extensive testimony that lasted over 2 days. And I am going to do the transcripts on her testimony also in the coming days. And let's see. So I won't go into all the details of her testimony in this recap. And let's see. Then on September 14th, which was day 16, There was a guy named Nicholas Williams who testified that he was a former intern, and he definitely had an issue with R. Kelly, and he seemed to be more upset that he wasn't able to interact with the celebrities that were coming to the studio. And then he wanted to say something to R. Kelly, but Judge Donnelly cut him off, basically saying that he couldn't. And he talked about the fact that they had a code word for Drea Kelly when she came to the studio, and that was important. And he would run and take this note to R. Kelly saying that someone important is here to see you. And then on cross-examination, Canick suggested that he was a disgruntled employee who never got the opportunity to work as a sound engineer. And then on cross, defense attorney Canick also suggested that Williams was nothing but a disgruntled employee and who was upset that he never became an engineer and got past the $6 an hour receptionist job that he had. And then Suzette Mayweather's sister, Alizette, she testified, and she was his personal assistant for 6 months. And she testified that part of her duties included escorting the girlfriends on shopping and various other excursions to get manicures or massages. She also said that services or transactions could not be handled by men. And should the girls encounter a man in an elevator, they had to turn their back toward the door. Which to me, if I was on the elevator with somebody and the people turned around, I'd be like, what the hell is going on? She said that she sent frequent texts to Kelly to let him know details of their whereabouts, indicating where they were going and when they would return. And then prosecutors introduced a series of texts by her, which she sent to her friend, in which she raised some concerns over the detention of one of Kelly's girlfriends, which turned out to be Ariel, and how she had to stay at the studio for like 36 hours. And then I think Copeland came back and testified that the reason Ariel was held in the studio was because she had some final exams or something that she had to do in order to graduate. And then the judge also ruled on the motion about a video and audio recording that was played to the jury only, and it was supposedly of Lisa Van Allen and Dominique Gardner. And then in the audio, I think it was Lisa Van Allen, where Kelly was cursing her out and yelling at her about stealing his Rolex watch. And then in the video, it was allegedly about Dominique Gardner, but evidently he was not in the video, so there really is no proof that it was him in the video. And then on day, let's see, what day are we on now? So that was September 14th. On September 15th, I think that was when they actually played the video and the audio. And then there's also there are petitions out, or letters or lawsuit about to be filed by the media, who wants Judge Donnelly to turn over that video and that audio so that the media can view it, so that they can further slander R. Kelly's name, because it's not like they actually want to say something favorable, but they want to get their hands. And I'm going to do a separate video on why I agree with them that it should be made public, not that I support the reason why they're doing it. And so they also, prosecutors introduced other videos, including a few which featured Kelly, a woman named Dominique, and a male witness by the name of Alex, who testified earlier that he met Kelly at one of his parties when he was 17 and eventually became his lover at the age of 20. And Alex testified that he participated in a number of threesomes that included the defendant. He went on to say that there were countless such encounters, that they were recorded by Kelly on his iPad. And the iPad recordings was a very common theme in the testimony. And then the government witness, Ryan Shabat, was a case agent for the Department of Homeland Security, testified about items recovered from the searches of the defendant's Trump Tower apartment and a storage unit. And then Shabbat introduced a number of letters recovered from search warrants. They read excerpts from the letters written by some of the alleged victims, and the portions read by the prosecutor range from girls groveling and asking for forgiveness for disappointing or failing Kelly in some way. And then also among the items recovered, what appeared to be the altered ID cards for Geronda Pace. The cards reflected a birth date of April 9th, 1990, 3 years older than her actual birth year of 1993. And you guys know that Geronda was the first witness to testify. And so that's what happened on the 15th. And let's see, let's go up here to the 16th. Okay, I think Cheryl Mike testified on the 16th. And there was a lot going on. Okay, not the 16th, on the 18th, because then we had the weekend. So this was day 18th, week 5. And so Cheryl Mike, remember, she introduced Precious Way, and Precious Way refused to even meet with investigators, let alone come in and testify. And so some of the points to her testimony was that, let's see, what did she say? That she was a talent manager who then went on to become his assistant. She talked about that she didn't want to testify. She said that she had a degree in business and management, and she began working in talent management in 1998-99. In August 2005, she was eating lunch with a client when a man approached them and asked who they were. The man asked Mike's client if she could really sing, and then he brought Mike and the client to the table in the back to meet R. Kelly, and Kelly thought that the client's voice was amazing, and they exchanged contact information. And then she collaborated with the client's album, but that was it. And then their relationship ended up contentious because the girl Precious was going to sue R. Kelly. R. Kelly demanded that Cheryl return to Chicago, and he wanted her to sign something basically telling her that she had to either be on Precious' side or be on his side. And so it was just a big mess. And then Tom Arnold, who was a studio manager and had testified earlier, drove Cheryl Mike to Kelly's lawyer's office, where attorney Jensen presented her with an affidavit and asked her to sign it. And then in the affidavit, it was like, did I ever see Kelly give Precious alcohol? No. Did she ever see them having sex? And it said she was supposed to say no. And she told the judge that she couldn't remember if she answered the questions or signed the affidavit. And when she returned to Atlanta, she didn't speak to Precious or Kelly. However, after some time, it was understood that the harassment claim had been resolved. And then years later, she began working with Kelly again and eventually became his executive assistant. And she talks about stuff that happened with Ariel, but I'm not going to go into all the details because hopefully I will get a moment to read the actual transcript to you all. And then after Cheryl Mike finished up, I believe that's when the specialist, the Don Hughes lady, came on, and she was the final witness, and she basically talked about the psychological effect of sexual abuse. And then we know that after Kanik cross-examined her, she admitted that she never met any of the Jane Does. She never interviewed any of them, and she never read any of the transcript. And so they were basically like, well, how are you giving us all this information if you haven't even met these people, don't know if they were telling the truth or anything like that? And so that was the end of the prosecution's case, and they rested, and then the defense took over. So guys, that's it for me. Go ahead and leave your comments below and let me know what you think about all of this. Okay. Do you think that the prosecution has proven their case based on their opening statement and based on the witnesses that testified, the transcripts that I have read, the updates that I have done? Do you think that they have met their burden of proof and that they have believed their case beyond a reasonable doubt? And then once I get more information on the defense, and I'm probably just going to do one video because their witnesses are so short, just a wrap up of what happened with the defense. And then I'll also read their opening statements, and then you guys can decide if they proved reasonable doubt, if they gave the jurors enough reasonable doubt to find Mr. Kelly innocent of all charges. So that's it for me. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.